Welcome to this deep dive. We're continuing our journey through the MPEP, the Manual of Patent Examining Procedure.
Right, the essential guide the USPTO uses for U.S. patent law.
And our goal here is to break down each section, make it a bit more accessible.
Definitely helps anyone dealing with inventions understand the U.S. system better.
Today we're tackling Chapter 2100. That's all about patentability.
Yeah.
But we're zeroing in on Section 2106, Patent Subject Matter Eligibility.
The big one. Section 101 territory. Basically asking, what kind of thing can you even try to get a patent for?
Exactly. What's the fundamental requirement? And it really boils down to two main criteria, right?
That's right. First, the invention has to fit neatly into one of 4 statutory categories. And second,
even if it fits, it can't be solely directed to what they call a judicial exception. Abstract ideas, laws of nature, things like that.
unless, and this is the crucial part, unless the claim as a whole includes something significantly more than just the exception itself.
Those 4 categories, again, are process, machine, manufacture, or composition of matter.
Seems simple enough on the surface.
But then you hit those judicial exceptions. Like you said, abstract ideas, laws of nature, natural phenomena. You can't patent gravity or a mathematical formula in the abstract.
Precisely. And figuring out where that line is. Well, that's been the subject of a lot of court battles.
Yep.
Big Supreme Court cases like Mayo, Alice, Bilski, and even going back to Deere, they really set the stage for the modern framework.
Yeah, they gave us what we now call the Alice-Mayo test. It's essentially a 2-step process examiners follow.
Okay, so step 1.
Step 1 asks, is the claim, as written, directed to one of those judicial exceptions, an abstract idea, law of nature, or natural phenomenon?
So that's the first hurdle. Examiners look closely at what the claim is really about at its core.
The MPEP gives some examples here. For instance, it mentions a situation with, say, a USB stick.
Okay, like a memory stick.
Right. If the claim covers both the physical memory, the RAM, which could be patentable subject matter, and something non-statutory like maybe carrier ways used to transmit data to it, that combination might fail this first step.
Why is that?
Because it might be seen as being fundamentally directed to just transitory data, the non-statutory part, rather than the statutory machine component.
I see. But contrast that with something like maybe a method using a mathematical algorithm. Algorithms often get flagged as abstract ideas.
Right. But if the method applies that algorithm in a very specific technical way, say to improve how a computer actually functions, making it faster or more efficient in a measurable way,
then it might pass step 1, because it's not just the algorithm itself, it's tied to a specific technical improvement.
Exactly. It's the application within a technical context that potentially saves it from being just an abstract idea.
Okay, that makes sense. So what if a claim is found to be directed to one of these exceptions in step 1? Game over.
Not necessarily. That's where step 2 of the Alice-Mayo test kicks in. The question then becomes, does the claim recite additional elements that amount to significantly more than the judicial exception itself?
Significantly more. That sounds subjective.
It can be, yeah. But the MPEP and case law provide guidance. It's about looking for an inventive concept, something beyond the exception that transforms the claim into a patent-eligible application of that exception.
So just saying do it on a computer isn't enough?
Generally, no. Simply adding generic computer components or saying perform conventional steps that anyone in the field would know, that usually doesn't count as significantly more.
It needs to be something genuinely inventive in how that underlying principle, that abstract idea or law of nature, is actually used or implemented.
Right. You can see the policy behind it. You don't want people locking up basic scientific principles or mathematical relationships.
But you do want to reward innovative ways of applying those principles to create something new and useful. It's a balancing act.
Definitely. Let's quickly circle back to those 4 statutory categories, just to make sure we have them clear. First, process.
Like a method, a series of steps. Maybe a new industrial manufacturing technique.
Then machine. That's probably what most people think of first. An apparatus, a device, like a new type of engine or tool.
Manufacture is next. That's an article that's been made. Could be simple, could be complex. Like a new type of composite material or a uniquely designed object.
And finally, composition of matter. This covers chemical compounds, mixtures, maybe even biological materials like engineered cells.
So your invention needs to fall into one of those boxes. That's the starting point before you even worry about the abstract ideas and laws of nature exceptions.
Which brings us to another critical piece. How do examiners figure out what a claim actually covers?
Claim construction. Yeah, this is hugely important.
During examination, they use what's called the broadest reasonable interpretation, or BRI standard.
Meaning they give the claim terms the widest meaning possible.
That's still consistent with how the terms are used in the patent's written description, the specification.
And how those claims are interpreted under BRI can completely change the eligibility analysis. There are some key court cases mentioned, right? Like Mentor Graphics, Enfish, Mecchi RO.
Yes, those are great examples. In those cases, the way the court or the patent office understood the scope of the claims was central to deciding if they were eligible.
So if a claim is interpreted narrowly as being tied to a specific technical solution, it might survive, whereas if it's seen as broadly covering just an abstract concept,
it's much more likely to be found ineligible under Step 1 or fail Step 2.
makes sense. The details of the language matter a lot.
The MPEP even mentions the tool examiners use to help with this, a subject matter eligibility flowchart.
Right, like a decision tree to guide them through the Mayo steps.
Pretty much. It outlines different pathways that go from the pathways A, B, and C, depending on whether the claim falls into a statutory category, if it's directed to an exception, and if it includes that significantly more.
Trying to bring some consistency to a complex area.
Exactly. And just for context, remember Chapter 2100, where this section sits, is part of the larger block in the MPEP, focused on overall patentability.
Yeah, looking at the MPEP structure, you see other chapters dealing with things like novelty, nonobviousness, but also what happens after eligibility, like allowance and issue or fixing mistakes via correction of patents.
And even entirely different types of patents, like design patents, which have their own rules.
It's a big landscape.
So summing up our dive into Section 2106, it really hinges on that two-step Mayo test.
Step 1. Is it directed to an exception abstract idea, law of nature, natural phenomenon?
Step 2. If yes, does it add significantly more an inventive concept beyond just the exception?
And underlying all that is the need to fit into one of the 4 statutory categories.
Right.
Process, machine, manufacture, or composition of matter.
Plus, how those claims are interpreted using BRI is absolutely critical.
And keep in mind, this isn't static. Court decisions, especially from the Supreme Court, continue to shape how these rules are applied. Section 2106 reflects the current understanding based on that precedent.
It sets a fundamental gate for what gets considered for patent protection in the U.S.
Absolutely foundational.
And before we wrap up, we definitely want to acknowledge Mike Shepard again. His work in coordinating this whole audio series is invaluable for making patent law more digestible.
Yeah, a big thanks for pulling this together. It's a great resource.
Okay, and now for our necessary disclaimer. Remember, this summary was generated using AI tools. It's for educational info only, not legal advice.
Please always refer to the official MPEP itself or consult with a qualified patent attorney or agent for any specific questions or guidance.
Definitely. Don't rely solely on this.
So as you go about your day, maybe look at new inventions or technologies you hear about. Try thinking about them through this eligibility lens we've discussed.
Where would they fall? Would they hit an exception? Is there something significantly more?
And here's something to mull over. With technology evolving so rapidly, think AI, biotech, quantum computing, how might these fundamental principles of what's eligible for a patent need to change or adapt?
Yeah. How will the courts and the USPTO grapple with inventions that maybe don't fit neatly into the boxes defined decades ago? It's a big question for the future.
Something to keep an eye on for sure. Until next time.